Okay, so this is going to be long. An update on the trial. It is officially over. That means final submissions have concluded. We will not know the verdict for a while, possibly months, for reasons I will briefly outline. The decision has the potential to set a precedent, a not insignificant precedent regarding just cause for terminating a contract, as well as the right of privately owned but monopolistic corporations who describe themselves as open to the public to capriciously and arbitrarily bar the expression of certain political views while giving a platform to others. The responsibility of said corporations to give proper notice as to prohibited conduct, and the ambiguity of language surrounding many companies' misconduct policies, Calgary Expos included. As such, the judge appears to want to review all of the evidence put before him in its entirety so as to leave no room for appeal. I think probably, for a judge, the only thing worse than having a decision you made overturned on appeal would be to have a precedent-setting decision you made overturned on appeal. Now, given that the trial itself is done, there is no danger of talking about it in public, tainting the testimony of the defendants. Please excuse the goddamn magpies! Or of revealing our strategy through public discussion. So we have decided to do one giant, massive public update on the trial. It's probably going to be split into two parts. And we will trust that Judge Day, who is adjudicating the case, Judge Fred Day, won't even look at this video, not even if it's directed to his attention by certain bad actors, and that even if he did, whatever is revealed here will not inform his judgment. He was very, very clear during the entire trial that there were certain things that would inform his judgment and certain things that he would consider irrelevant, which I will probably be elucidating on a little later on. So essentially, he's only looking at the pertinent facts, and when he's exposed to other things, other information, he weights it accordingly. If it's not relevant, it's not relevant. Nevertheless, we will not be directing his attention to this video. That would be a clear attempt to prejudice his decision, and we don't want to do that. We want to be above board and doing things properly all the way through. Now, we're also not making this video to proselytize or to grandstand or to, make a big public hairy deal out of this. It's just for the simple reason that there are people who want to know what happened. There were several people, anywhere between 5 and 15 people in the gallery, the public gallery of the courtroom throughout, but there were no members of the press, so there's been no reporting on this really, and basically anything that I tell you here, this is all, none of it is privileged information. Any of the private citizens who were present in the gallery observing the trial or in the conference room or sitting outside the courtroom would be able to speak about their observations of what happened publicly. What occurred in the courtroom will comprise the majority of what I'm going to reveal here, and more than this, pretty much everything presented here is a matter of public record. So there you go. We're in the legal clear as far as discussing these details. Now, just to refresh everyone's memory, this suit stems from our group's expulsion from Calgary Expo back in April of 2015. Over the course of this trial, we made our case that Calgary Expo breached its contract with Alison by evicting us without any proper investigation beforehand on the morning of the first full day of the convention. There was a half-day Thursday from, I think it was 5 to 9 p.m., and we were kicked out when we arrived to set up our booth the next morning. So, we allege that the Mary Sue induced this breach of contract via the conduct of at least one of its agents who was present at the expo in her capacity as an editor for the website. It's our contention that even if this editor was not in direct communication with Calgary Expo, she sent a photo of our booth to a longtime friend and collaborator of hers, either requesting or hoping this friend would publicize it in an attempt to generate public controversy and public animus against us, which is exactly what happened. At least everything that followed from that tweet is what contributed to what happened to us. We contend it was this public controversy that inevitably led to us being kicked out without any proper investigation. Now, of course, we don't know necessarily that this person was specifically asked by this editor for the Mary Sue to do this, or what the intentions were in the editor's mind when she sent that photo. And indeed, we are not 100% sure that it was the editor at the Mary Sue who sent it, but what we're working with in a civil court is a balance of probabilities. We don't need to prove things beyond a reasonable doubt. And so we're confident that this would be something that the judge would seriously consider. We also allege that both parties engaged in injurious falsehood against us, the Mary Sue by publishing falsehoods in an article about the incident with malice. So malice in the legal definition means falsehoods that they knew or should have known were false without taking the proper care to check, and also malice because they don't like us. And the Calgary Expo for tweeting that article in response to people on Twitter who were asking them why we were expelled. These falsehoods then resulted in damage to Alison's business reputation. They essentially portray her business model as, one where she misrepresents herself in her contracts and uses those lies, that type of fraud, to sneak into conventions for the purpose of engaging in disruption and harassment. So that's sort of the narrative that's been publicly woven regarding all of this, is that this is just what Alison Thiemann and the Honey Badgers do. Lie on their contracts so that they can go harass people. So I'm going to go all the way back to the first days of the trial, back in November, and give an account of what happened. Now, initially, the co-defendants, the Mary Sue and the Calgary Expo, were represented by separate legal counsel. And that's typical because even when you have two defendants who are being accused of similar or the same things or acting in concert with each other, they may end up having competing interests at some point. So usually they choose separate counsel in order to make sure that each defendant's interests are individually protected from any kind of wrongdoing or wrongfully laid blame on the part of the other. Now, at some point, the Mary Sue bizarrely decided that their interests would also best be served by taking Calgary Expo's legal counsel on as their own. So eventually both clients became represented by one law firm, the law firm Beaumont Church. And their lawyer on record, who was with that law firm, an associate with them, was Elmer Chu. Now, at some point, and I don't remember exactly when, between our filing of our statement of claim and those first scheduled trial dates, Elmer Chu left Beaumont Church and struck out on his own, and these two defendants decided to stick with him rather than with the law firm Beaumont Church. In January 2017, the trial dates were completely eaten up by an 11th hour motion for summary dismissal on the part of the defendants. They had several grounds to argue before Judge Day as to why he should dismiss the case out of hand before trial, and they submitted 2 affidavits, one for each defendant, and several exhibits in support of those affidavits, and I will itemize them here for the record. So, in moving for summary dismissal on the causes of action relating to Calgary Expo, the arguments were that they were correct in evicting and banning Alison Thiemann and her agents because Alison and one of her agents engaged in harassment at a panel discussion on women into comics. Also that they were correct in evicting and banning Alison Thiemann and her agents because they had no idea Ms. Thiemann would be attending Calgary Expo as a representative of Honey Badger Brigade, as she had allegedly misrepresented herself on her booth application. Now, in support of these claims, they submitted several pieces of evidence, including Alison's booth application, which clearly stated her company name as Honey Badger Brigade, her company website as honeybadgerbrigade.com, and her company email as honeybadgersradio@gmail.com. Now, they also claimed they had in their possession a video depicting events at the panel discussion, which made it clear that Alison had indeed engaged in harassing behavior there. And while they did not state that they had reviewed this video prior to evicting us, they inferred it by not clarifying that the video they were referring to was one we recorded and uploaded to YouTube after having been evicted. Now, the arguments for the Mary Sue included the above as well, and also that the Calgary Expo had confirmed the version of events that they published. So they're essentially saying, probably referring to that tweet and other tweets that exist, referring to the reporting on the incident made by Calgary Expo's official media account, that the allegations that they published were confirmed by Calgary Expo. They argued that the Speech Act in the U.S. bars defamation claims from foreign countries from being enforced in the United States. They further argued that the tort, injurious falsehood, is the same as defamation. It's not. And therefore, not only would any ruling made by a Canadian court not be enforceable in the U.S., but the lower court had no jurisdiction over this case, since defamation cases have to be heard in the Court of Queen's Bench. They also asserted that Sam Maggs, one of their editors who was present at the convention, the editor in question, was not in attendance as an agent or employee of the Mary Sue, but as a private citizen. So even if she committed some wrongful act against us or was implicated in abetting said wrongful act while there, the Mary Sue could not be held responsible. Now, first off, there is no published comment from the Calgary Expo in the Mary Sue article indicating that the Calgary Expo confirmed any details that they presented in their article, other than the fact that we were indeed evicted and that we had vacated the premises before the public was allowed access to the venue on the second day of the convention. So that's why I'm assuming what they're referring to there is those public tweets. Second, the Speech Act is not a carte blanche for American citizens to engage in defamatory language against people outside of the U.S. The Speech Act has a very narrow application. When a foreign judgment of defamation is registered in a U.S. court, that court now, since that act passed, has a duty to consider whether the outcome would have been the same had the case been tried in a U.S. court under U.S. First Amendment principles before they enforce the judgment. So that's all it means. Would this situation count as defamation here? If so, we will enforce it. Third, injurious falsehood is not the same as defamation. If it was, it would not be able to be tried in small claims court or the lower court. There are clear and concise differences between the two torts, which I have described elsewhere, and I can link to that in the low bar. If the two were the same, again, a lower court would not have jurisdiction over injurious falsehood claims because defamation cases can't be heard in the lower courts. Fourth, the judge ruled that because Sam Maggs had communicated with certain people who she then directed to contact the author of the Mary Sue article in question, she was indeed acting in her capacity as an agent for the Mary Sue. Even if she didn't go there to act in that capacity, while she was there, she was acting in her capacity as an editor. And therefore, yes, the Mary Sue is responsible or could be held responsible for her actions. So even the most difficult of the causes of action we had to prove, the inducing breach of contract against the Mary Sue, that was upheld as having enough merit to continue on to a trial. The judge ruled against the defendants in every single cause that they had to bring a motion for summary dismissal, and so there you go. Calgary Expo also, in their motion, argued strenuously that a misnomer in our statement of claim, one where we left a word out of their corporate name, in just one instance of several instances where we named them. That was a reason to throw out the case, because we had named the wrong defendant, and as well as the fact that our claim had been amended to correct the name of Calgary Expo at least 3 times prior to that. They said that we were suing the wrong entity, number one, even though we correctly named them in several other places in the statement of claim, and that we had wasted the court's time by misnaming them several times prior to that and having to amend our statement of claim. This is highly ironic in light of the fact that it took months of searching and repeatedly asking them, their counsel, for Calgary Expo's actual corporate name. We knew the owner of the expo, Kendricks Fung. We knew who he was. He turned out to also own several other similarly named companies, whose names were easily searchable on free public databases and registries. The actual name of the actual company, he registered that in a provincial registry where you would have to go into a registry office and pay for a search to be done by a government employee to find out that company name. And basically, we went by the name of the company, initially the name of the company who owned the official Calgary Expo website. That was apparently the wrong name. Then we went to the name of the company that gave Alison a receipt for her booth rental at Calgary Expo, and apparently that was the wrong name. So, I mean, like, you're looking at somebody who's trying to hide the corporation under which he's really doing business. And moreover, at one point during a pretrial hearing months before that, Mr. Chu was ordered by a judge to disclose to us the real corporate name of his employer, and he did so, or he thought he did. About a week or so later, maybe 2 weeks later, he sent us a letter indicating that, whoops, that actually wasn't the right name either. I didn't actually have it in front of me at the time, so I accidentally told you the name of yet another nearly identically named company owned by Kendricks Fung. So, Calgary Expo described this situation of their own orchestration as us intentionally or negligently wasting the court's time and bucking the court. So more than a day of court time that was initially slated for the trial itself was wasted by the defendants arguing these ridiculous premises in an attempt to get the case thrown out. On the second day, in I think it was the early afternoon, Judge Day ruled in our favor on all causes of action, allowing the case to go ahead. At that point, he gave us an option. We could begin the trial proper, then and there, with him, and continue it over 2 days the following December, so December of 2017. Or we could have 3 full days the following November, so a month earlier than that, but it would be under a different judge. Now, the only good reason to continue the trial on that day would have been to have some of our out-of-town witnesses testify so they wouldn't have to come back, but that actually wasn't an option. Alison had to testify first because as a party to the case, she has a right to be in the courtroom through the entire proceedings, and she could have had her testimony tainted by watching other witnesses testify before she did. So, you know, she had to testify first, and we knew her testimony would take an awful lot longer than half a day. So we decided that we would choose the November trial dates, November 29th through 31st, 2017, and choose a different, to go with a different judge. Turned out that it was going to be Judge Laura Burt. Now, incidentally, the rulings on the motion for summary dismissal that were successfully argued in our favor by Harry Capito, our legal agent, they have set precedent and either will have been or will be entered into the case law going forward from this. So, let's move on to the next chapter, November. Initially, I was on our witness list, and then about 3 weeks before the trial was about to start, something weird happened, completely out of the blue and unexpected. Counsel for the defense, Elmer Chu, sent me a notice to attend via his assistant, and in it I was ordered to be available in Calgary to testify on behalf of his clients for the full 3 days. According to this notice, financial compensation for this legal requirement, for which I could be arrested if I refused, consisted of $100 for every day or part of a day that I was required to be available. Noted in that same document was that $100 per day for 3 days amounted to a total of $100 that they owed me for my trouble. And they asked me whether I wanted to pick this payment up in their offices in Calgary or whether I'd like to have it mailed to me. So, I replied to Mr. Chu's assistant and pointed out their very strange math, and I informed them as well that I live in Edmonton, which entitles me to have a lot of my expenses covered by them. I linked them to a schedule of fees, allowances, and compensations, which I itemized and totaled for them in my words using basic arithmetic, and determined that they owed me $996.64 for my trouble, and then asked them to please mail a check to my home address. Now, they never got back to me on that. So on Friday, November 24th, the Friday before the trial, at about 11 a.m., I emailed Chu's assistant, gave her a bump to indicate to them that I hadn't received any money and I hadn't heard anything back. Now, around 1:30 p.m. on Sunday, the 26th, just 2 days before the trial was to begin, and after I had already left for Calgary, Mr. Chu, not his assistant, emailed me to inform me that I was released from my notice to attend, and then he asked that I advise him as to how he could expect that I would return the money he had sent me for my witness allowance. I emailed back to tell him that I was unsure whether he wanted the $0.00 he had paid me thus far to be returned by hand to his office, or whether he would accept a check sent by registered mail in the amount of $0.00. What can I say? I couldn't resist. So there we were in Calgary the day before the trial, and Harry asks me, is there anything that you could actually testify to that somebody else couldn't? And I thought about it, and while I think I would have made a great witness, there really wasn't anything that happened in my presence that wasn't also happening in the presence of our other witnesses. So, at that point, Harry asked me to act as his assistant in the case. He dropped me from our witness list, and that meant that from that point on I was present for almost everything. I was taking notes and helping Harry make sense of the evidence and keep track of documents. And a lot of that evidence took the form of tweets and emails, which are maybe not so easy for someone Harry's age or the judge's age to really grasp. And I was also observing the entire thing from the plaintiff's table. So the first morning of the trial, when we arrived at the courtroom, courtroom 1506, I believe it was, 1506, the dockets were all messed up. We were supposed to appear in Judge Burt's courtroom, but looking in, we noticed it was Judge Day in there dealing with other cases that were more briefly dealt with than ours. The court clerk says the courts double book all the time, and so essentially, even though you're supposed to be in the courtroom, doing your thing at 9 o'clock, usually there's some other people's business needs to be attended to first. There were a couple of people who were unsure, unable to figure out which courtroom they were supposed to appear in. They kept getting sent back and forth between 1506 and 1508. Those would be Judge Burt's and Judge Day's courtrooms, by the clerks, and the clerks were just ripping their hair out trying to figure out what was going on. So Chu comes up to us in cutthroat mode, right, in the hallway, and he barks at Harry, "I'd advise your client to drop the case now. I know she owns a property in Saskatchewan, and when we win, we will be going after costs." And so Harry just sits there. He's kind of unperturbed. I don't even think he looked up at Chu. He said, "We'll take it under advisement." Anyway, so because Harry had essentially told her that there was this vulnerability there regarding any property that she owned, or that Honey Badger Brigade owned, she was a little bit upset by this threat. Harry kind of shrugged and said, "It's only money. No, the defendants don't want to own a share in some tiny office building in buttfuck Saskatchewan. That really the worst that they could do is they would make her liquidate all or some of her share in the building. That's easily done through a mortgage or a line of credit. The biggest nuisance the defendants could make of themselves if they won and if they were given costs would be to put a lien on the property, and that just means you can't sell it, and she doesn't want to sell it anyway. And the only reason the Badger Cave even matters in this context is it would demonstrate she's not impecunious, that she could pay the costs if necessary. So essentially Chu was just trying to make her panic and kind of being a real giant dick about it. Anyway, we were finally able to go in to the courtroom, and wouldn't you know it, there was Judge Day on the bench. The judge who had heard the defense's motion for summary dismissal, not Judge Burt. And at the end of that first day, we actually asked the court clerk, he was really helpful and friendly, and I forget his name, I wish I could remember it, to give him a shout out. We asked him whether Judge Day had actually requested the case, and he said, yeah, Judge Day and Judge Burt had traded dockets, and that had been the source of all the confusion at the start of the day. He indicated to us that injurious falsehood is an almost never used tort, that the vast majority of judges have no experience with it, and that Judge Day had already had to do a lot of reading on the law just to rule on the motion for summary dismissal. And so when Judge Day went to Judge Burt and explained all of this, that he was familiar with the law in a way that she probably wasn't, and also familiar with some of the details of the case, she was happy to hand over that particular case to someone who had that background rather than start from scratch herself. So the first thing that happened after walking into the courtroom, seeing Judge Day there to adjudicate the case, was submitting the evidence binders. Now, Alison had this gigantic, fat, a set of 4 gigantic, fat, I think they were 5-inch, maybe 4 or 5-inch binders, and they were like stuffed full of evidence. And, you know, she said afterwards, you know, if I ever do this again, I'll be submitting binder number 1, binder number 2, binder number 3, rather than all of it in this one big binder, because it was really cumbersome to flip back and forth between pages when necessary. Also, Chu, Elmer Chu, complained about the fact that the evidence binders Alison had put together contained evidence that had not been properly submitted, not submitted before the deadline. And so, essentially, he was saying, you know, like, there's just, we can't use these binders. And that's, I mean, that's somewhat proper to do. You don't want to have evidence that's been submitted improperly, you know, go in front of the judge. So he essentially said these binders are improper, and we can't use them until we make sure that all of this evidence that was not submitted, that we did not have until just now, gets taken out of them. And so there you go. Now, she knew which pieces of evidence they were, and she offered to take them out. Chu wouldn't take her word for anything. First, he kindly offered to let us use his own evidence binders that contained almost none of our evidence, and we objected to that. So the judge told both parties to go through our binders, find the contested evidence, remove it from the judge's and defense's binders, and said he would deal with each piece of contested evidence when it came up during the course of the proceedings. So for close to 2 hours, Alison and Chu were in the conference room. Chu made her verify by digging up emails on a borrowed cell phone that every single item in her binder had been submitted before the deadline. This includes items they submitted, that the defense had submitted, and that were then scooped by our side to act as our own exhibits, and even items that were clearly in his own binders. So finally, near the end of the morning session, it was time to commence the trial after Alison had gone through every single piece of evidence, page by page, to prove to Chu that she'd submitted it on time. The judge asked that any witnesses who were not also parties to the case were to leave the room, and I stayed where I was at the plaintiff's table. So Chu stood up and he said, Your Honor, there's one plaintiff, but there are two women sitting at the plaintiff's table. And Harry stood up and said, Your Honor, this is Karen Strawn. I've asked her to act as my assistant, to take notes, help me keep track of my documents. I beg the court's indulgence to allow her to stay. Chu kind of barked out, Is she your staff? And Harry said in his self-deprecating manner, No, Your Honor, she's not my employee, but she's been involved in this case from the very beginning, for 2 years now. She knows the details inside and out. I would beg the court's indulgence to allow her to act as my assistant. The judge then confirmed that I was not going to be a witness in the case for either side, and Chu was not pleased at the judge's decision to allow me to stay. We were guessing he only released me from the notice to attend because I was also on our witness list, and he figured he'd get a crack at me on cross-examination without having to pay that $1,000. And now he was hearing that he wouldn't get the chance to question me at all. So, and I still have zero clue as to what on earth I could have testified to that they would have wanted to get a crack at. So, like, I have no idea why they wanted me to testify for their side. But it just goes to show you should have forked over the money. The judge allowed me to stay, and that means I was there for the entire thing from that point on. So, next up, opening statements. So the judge asks Harry to step up, give his opening submissions, and magnificent bastard that he is, he stood and said, Your Honor, you've already sat through more than a day of arguments on the defense's motion for summary dismissal. You're well acquainted with the case and the reasons it's been brought by my client. I'm not interested in wasting the court's time retreading old ground, so I waive my right to an opening statement. So then Chu takes the podium, and he was reading from prepared notes. 80% of his opening statements referred to matters that were already ruled on by Judge Day. The Speech Act, injurious falsehood is the same as defamation, therefore the court has no jurisdiction. The fact that the plaintiff had already wasted court time by being unable to accurately name the corporate entity responsible for the Calgary Expo. Things like that. So the judge was really not pleased. He asked, What is this, Mr. Chu? Are we going to rehash my prior rulings here? And honestly, I don't think it escaped Judge Day that it was entirely likely that when Chu prepared his notes from which he was reading, he was planning to present them to a different judge, Judge Burt. And the implication of that is that Chu had been planning to try to convince Judge Burt to undermine, overturn, or disregard Judge Day's prior rulings, which is not cool, brah. Not cool. In fact, when I relayed the bare bones of this series of events to my then 15-year-old son and reminded him that Chu had probably prepared his opening remarks to be presented in front of Judge Burt, even he was all, holy shit. Even he understood the implications of that. So it's astounding to me that Chu would not have realized that this was probably not the way to go. So after getting that dressing down and settling down a little bit, then Chu did something like, as if in possession of the gonads of 1,000 elephants, he made a request of the judge. Like a really improper and I don't even understand if this is a request that's ever been made. Your Honor, if the court pleases, I would ask that my client, Mr. Icebrook, be allowed to add a few words of his own to our opening statements. So the judge asks Icebrook to state and spell his name for the record. The two of them went back and forth almost playfully with the pronunciation. Icebrook, Icebrook. Icebrook? No, Icebrook. So then Judge Day sits forward in his seat and he says, Mr. Icebrook, I understand that you're from the U.S. and things are done differently there. I watch TV too. But here in Canada, it's customary to stand when addressing the court. So Icebrook shoots to his feet, and the judge then says, "Mr. Icebrook, in what capacity are you attending my courtroom?" Icebrook says, "I'm Chief Operations Officer and General Counsel for the Mary Sue." "So you're a lawyer?" "Yes." "But you're not the legal representative on record in these proceedings?" "No." "So you're the client?" "Yes." "Are you trying to wear 2 pairs of pants in my courtroom, Mr. Icebrook?" says the judge. "What's next? Are you going to want to cross-examine witnesses, too?" "Of course not, Your Honor." Judge says, "You're the client. You have retained counsel. It's your counsel's job to speak to this court on your behalf. Take your seat, sir." Like, boom. So, the defense was really not off to a good start. I do have the confidence that this particular judge won't allow that to prejudice him. I think he's probably seen things even more ridiculous in his time as a judge. He's semi-retired now, and he's probably over 65. But certainly wasn't. It was certainly a waste of the opportunity to make proper opening statements. And then after that, Alison was called to the stand. Her testimony took the rest of that day and the remainder of the second day as well. Every contested piece of evidence Chu had wasted 2 hours making Alison remove from the binders. All of that was admitted into evidence as it arose. Every objection that was made by the defense was overruled except for one. That's not to say Judge Day was favoring us. He showed a clear pattern going forward and through the defense's putting forth of their case of not allowing evidence to be excluded on technicality. He seems to be a guy who wants to see the entire picture and as much of the evidence that he can. And he demonstrated that in all of his subsequent rulings in our favor and also against us. So the only thing that he actually refused our side was Alison wanted to make us all listen to the full 1-hour recording of the Feminist Women into Comics panel discussion. When the judge asked why she wanted to have us listen to the whole thing, she said, "So you'll realize my behavior wasn't any different from the behavior of other audience members, that it was an informal panel and other people in the audience were also chiming in with their thoughts." So the judge said he was willing to take her word for that, and he allowed that if the defense suggested otherwise at any point, then we would all get to listen to an hour of feminist panelists talking about comic books in reply to that suggestion. Frankly, everyone in the courtroom, including me, maybe especially me, was pleased to hear the judge rule that the fullness and completeness of this evidence was not required for him to take her word for the fact that she was not behaving any differently than anybody else who was at that panel. Now, at one point, when Alison was describing the events immediately surrounding our eviction, she got upset. She asked the judge if she could have a break, and I recall her saying, "I'm trying to remember very carefully," and then asking to take a moment, and he said, "For sure, you can take 5 minutes, right?" She was halfway out the door before he'd even formally dismissed her from the witness stand. And so when she came back after the break, she apologized for that, and the judge was understanding and gracious. He said, "Thank you. I appreciate the apology. It's not necessary. Testifying is stressful. This kind of thing happens all the time." So that was nice. At another point, regarding an archive of Calgary Expo's tweeting of the Mary Sue article. So we had an archived library of what was found at that URL of that tweet every time somebody actually looked it up in that archive site. And at one point it was there, and then at the next point it was gone, and so we knew it was between those 2 points in time that the tweet was deleted by Calgary Expo. So she was asked to explain the implications, and she said, well, you go to the archive site and you put in the URL, and if you look at the URL, and then Harry asks, "What's a URL?" And instead of saying what any normal, non-nerdy person would say, it's the www.whatever.com, right? She answered, it stands for Universal Resource Locator, also tech blah blah blah, nerd blah blah, no normie understands what I'm describing, blah blah, right? And I'm starting to laugh behind my hand because all Harry wanted to know was where he's supposed to look at, what he's supposed to look at on the page. And Alison was giving him a lesson on internet fundamentals, and the judge says, at that point, it's not polite to laugh at old people just because they don't know what a URL is. And I glance up at him, like I'm actually, oh shit, right? But I glance up at him and I see he's joking, right? And then he states, for the record, I was being a bit jocular there. And at that point, I got up and I pointed out to Harry what he was supposed to be looking at, right? Alison then went on to explain very well how the archive sites work and that you can narrow down when something was deleted based on timestamps in their libraries, and the libraries can be deleted, but they cannot be edited on request. So Chu got up and objected, saying that this evidence hadn't been verified by an expert, and Alison was acting as if she is an expert. So then Harry asks her to describe her experience with the internet, and she said she'd gotten on the internet back in the early 90s or something, and then she frowned and said, well, that's not really accurate. It wasn't actually the internet back then, since the hypertext transfer protocol hadn't really been adopted yet, and that protocol was pretty much the start of what we think of as the internet. And then she went on from there to churn out a whole bunch of equally esoteric and boring tech stuff. So basically, Chu's objection backfired spectacularly. Anyway, by the end of the second day of the trial, Alison had been giving direct evidence for a day and a half anyway, and she still wasn't finished. Her evidence binder was a thing of absolute beauty. The order of the evidence in it, the order in which she had put it in there to go through, wove an entire story that was very easy to follow, and all that was left was primarily testimony as to her losses and damages. If I recall correctly, near the end of the second day, she went through a collection of industry and mainstream news articles about the eviction, all of which, even the ones without serious bias against us, linked back to that initial Mary Sue article. And when she was asked why she had included them, she said, this is my professional reputation now to anyone with a computer and an internet connection. Anyone thinking of offering me a job or doing business with me, no matter where they are in the world, they're going to find this. And something else interesting that happened that day. Judge Day apparently had lunch with a high-ranking Edmonton-based judge who was in town. They had been discussing the case and how complicated and lengthy the trial was turning out to be and how little money really was at stake. So after lunch, Judge Day told us that this other judge, and for the life of me I can't recall his name, offered to volunteer his time to sit down with the parties in an impromptu case conference and see if he couldn't help mediate a settlement. And he asked us, sort of before the beginning of the afternoon session, to consider it and give our answer to him at the end of the day. He assured us as well that the conference would be off the record and without prejudice. The parties agreed to try it at the end of the day, and the rest of us, including me, sat outside the courtroom and waited while this case conference went on. Now, looking in, I could see Alison getting more and more annoyed. She was getting up and rooting through her binders to find things. She later told me that Shane Henkelman, who was there as the client, Calgary Expo, had lied to the judge about certain things that he would not know were lies because he hadn't been in the courtroom watching her give evidence for the last day and a half. And she was looking for the evidence to demonstrate that he was not being honest. Now, this went on for about 2 hours, after which Alison comes shooting out the door like a bullet with Icebrook from the Mary Sue on her heels. The two went off down to one end of the hall, the end furthest from the elevators, and they were engaged in what appeared to be an intense conversation. Harry seemed completely unperturbed, as usual. He just kind of sat down and started surfing on his phone. Henkelman and Chu were standing at the other end of the hall, right by the elevators, waiting and on the phone and stuff like that. And two security guards were standing right in the middle of everything, waiting for us all to get the fuck out of there, since the courthouse had been closed for like an hour and a half or something like that. So I finally asked these security guys, could you please just go separate those two? I'm not getting in between them, right? But if they aren't split up, we're never going to be out of your hair. So they went over and told the two of them that they needed to shut the fuck up and leave the building, basically, much more politely than I would have. So Alison comes rushing over to join us. Icebrook's still trailing after her. He's saying, like, okay, let's meet back here at 8 a.m. tomorrow then. And she just kind of mutters, yeah, fine. And he finally went off and joined his group, and we all left as well. Now, at some point that evening, Alison and I and the rest of us, I guess, really, because we were all staying in the same place. We had a talk, and she said, kind of as if discovering it for the first time, something like, they can't actually do any more damage to me than they already have. And that seemed to change her attitude towards everything quite a bit. She had been quite anxious up to that point, but now she seemed angry rather than anxious, and that was preferable, at least, to me, in terms of her being able to deal with the stress of, all the things that were going on. So the next morning, we were indeed at the courthouse early, but it wasn't to meet with Icebrook. I don't even know if Alison registered his request for a meeting, and if she did, it was like completely left her mind, like, within a few seconds. We were there early so that she could sort out her binders, which were an absolute mess from her leafing through them during the case conference. And unlike our Airbnb, the conference room outside the courtroom had a really nice big table that was perfect for doing that. So she's just kind of going in between, like, sorting and stacking pages and then going off on these, like, rants. Chu knocks on the door and then sticks his head in, and he asks if Harry's in there, and she just snapped no and shoved the door shut, like, right in his face. A minute or so later, Icebrook sticks his head in and he says, "Do you have a minute, Alison?" And she didn't even look up. "I'm busy with my documents." And then slam. I'm actually surprised neither of them got banged in the face. But she just had, like, she was going to give them zero time of day. And then Harry comes in, and I told him that the other side wanted to talk to him. And he goes and he talks to them, and then he comes back, and he says they want to talk settlement. So Alison slams her papers down, and she's just standing there, like, kind of glaring directly into the middle distance, straight ahead, fuming, and for a few moments. And then she just charges across the hall to the witness room where they were and starts in on Chu. And I'm going to paraphrase here. I can guarantee there were a lot more words involved and probably a lot more information that was conveyed, but here we go. She yells at him, "Everything your clients could do to harm me, they did 2.5 years ago. Everything they could take away from me, they took 2.5 years ago. Your side has been doing nothing but dragging this out on and making it impossible for me to get on with my life. And now you want to settle?" And then she charges back into the conference room and grabs her papers and starts shuffling them again. And then she slams them back down and charges back across the hall to add, "And by the way, you wanted to threaten me with costs at the start of this trial, threaten to take away more of the things I care about? Fine, you can go after your costs, but I guarantee there are dozens of people lined up who are willing to help someone like me stand up against people like you. And if I ask them to help me pay your stupid costs, I will have the entire thing funded within a day." So the three men in the witness room, they're looking a bit stunned, I'd have to say. I think Henkelman was yelling, "I'm so sorry, I'm so sorry, I'm so sorry," through some of it. And Icebrook was just, like, completely taken aback. Anyway, so we go back into the conference room and close the door to discuss what to do. And that conversation involved a lot of the people who were there to support us, who were not witnesses, but to observe the trial from the gallery. They were included as well. Harry recommended that we at least talk settlement, and I agreed. Alison's contended right from the beginning that she wants a judgment. something that would be on the court record, that would benefit other people, not just her. And we all agreed that that's not only what our patrons wanted when they donated to our legal fund, but it is the absolute best outcome. And we assured her as well that talking settlement isn't the same as agreeing to settle. And at the very least, we should hear their side, hear their offer, and then decide to not take it based on what it contains. So we go into the courtroom, and we informed the judge that we were in the process of discussing settlement terms. We asked for a temporary adjournment. That left us with the right to return to court if we couldn't come to an agreement. Now, for the rest of that day, we went back and forth between the witness room and the conference room, trying to hash out the details. At first, Calgary Expo seemed fairly reasonable on the things that we really wanted. They were prepared after some negotiation to put out a public statement to the effect that after hearing the evidence presented in court, they determined we did nothing wrong, and an apology and an invitation to participate in future conventions. So that was actually a pretty big deal, an admission of wrongdoing on their part. But when it came to a question of monetary compensation, Henkelman said he was authorized to offer us something like $3,000. Of course, that's not even remotely satisfactory. It doesn't even cover the damage to Alison's custom booth installation, damage which only occurred because Henkelman demanded that we tear down and remove a massive installation that took 5 hours to set up, and that we do it without any tools within half an hour, or he'd call the police and have them remove us. So, and then you look into like the burden and the expense and all of the time and effort that we've had to put into just to get them to publicly admit what they did wrong. And he's not going to compensate us for any of that. It certainly doesn't even include or cover the cost of the booth rental itself, which was not refunded, or the parking passes we'd had to purchase, also not refunded, or any of the lost sales she'd suffered from this, any of the lost opportunities that she would not have due to her business reputation being destroyed and being banned from a marketplace, essentially, a monopolistic marketplace. So she told him that we'd talk money later. Now, Icebrook was much more recalcitrant. He initially said there would be no monetary settlement at all, and he has stuck to that. And he initially offered to let us post an article on the website, the Mary Sue, telling our side of the story. We wanted an update to the original article, posted at the very top, as long as we wanted it to be written by us, unedited, where we could say whatever we wanted about the author, Jill Pantozzi, and the website itself within the bounds of the law. Then he said it would be illegal to alter Ms. Pantozzi's article because of copyright law. I called total bullshit. I told him we aren't idiots. We deal with copyright issues all the time. And we know Mary Sue owns the copyright to any of the articles on its website, and they can do whatever they want with them, including deleting them. Then he said, okay, well, we'll post an update with a link to this separate article down at the bottom. And that's what we'll do. And eventually, I went up to Alison and I put my hand on her shoulder and I said, we could always settle with Calgary Expo and then continue the case against the Mary Sue as a lone defendant. Icebrook looked a little displeased by that. Alison looked at Chu and said, we could do that? And Chu confirmed it to her. He's an officer of the court. He can't lie about something like that. So then Icebrook starts being more reasonable. Or less unreasonable, I guess. He says he'll append our text, full text of our article, at the bottom of the original article where the other updates are. And I'm like, no. How many people are going to read all the way to the bottom of that pack of lies to even see our update? And of those, how many of them will have been prejudiced by reading the original article first and seeing the update after? Here is what I want. I want to be able to write "The Mary Sue sucks" and "Jill Pantozzi is a big fat liar" right at the very top of that article, directly under the headline, in whatever font size and color I choose. And then Alison says, and then I want you to email a link to the updated article to every single journalistic outlet that reported on this using the Mary Sue as a source, and explain to them what the situation is. So basically, we wanted something that in some ways was better than a judgment of fault on their part, made by an adjudicator. We wanted a public admission or indication that the Mary Sue lied about us and that Calgary Expo breached its contract with us and then repeated the Mary Sue's lies. And we felt that being able to say at the start of whatever update we made to their article, to say that this is part of a settlement agreement, I think that that would maybe be, in some ways, better than a judgment that they could say, well, the judge made the wrong call. And then on top of that, Icebrook was initially saying not only was there going to be a non-disclosure agreement attached to any settlement, but so we would not be able to disclose the terms of the settlement, but that there would be a non-disparagement agreement, not only applicable to the article or the author of the article, but to any content published by the Mary Sue. We would no longer be able to criticize a feminist website, because that would be disparaging them, and that would be against the terms of the agreement as he wanted those terms to be, and we had to argue him down from that and say, we're going to say whatever the fuck we want about your stupid website within the bounds of the law, right, of defamation, libel, and slander law. So, essentially, there was a lot of having to negotiate to get him to be even in any way willing to give us the primary thing that we wanted, which was some indication that they knew that they had done wrong by us. And a public indication at that. So, essentially, we wanted them to have to fork over a certain amount of money, particularly if we're going to do them the favor of waiving our right to a judgment in the case. And eventually Icebrook conceded to most of the non-monetary things that we wanted from him, but he was still adamant that there would be no monetary settlement, and Alison was equally adamant that there would be. And at that point, it was just late in the day, and we were all exhausted, and we agreed to call it quits for now. And Alison asked Chu if he would write to her by a certain time and date with what he believed had been agreed to thus far, and told him we would go from there. Okay, so we all head back to the Airbnb, only to discover that Brian and Sage, neither of whom were fully aware of the situation. They had not been present for any of these negotiations. They hadn't expected to be at the courthouse at all that day, and were sort of just hanging out downtown. They had posted public updates that were misleading as to the state of the case. So we had them take the posts down and issue corrections on them the moment that we found out that either that the posts themselves were misleading or that people got the wrong idea from them. We didn't want either. So essentially, we had them deleted and publicly corrected immediately upon discovering them. Now, near the deadline, which was after we'd all gotten back home to our respective towns and cities, Chu sent an email without prejudice and with a note that the terms had not been agreed to yet by all parties, containing what he apparently believed had been agreed to. And of course, it included no monetary settlement from the Mary Sue and a $3,000 settlement or something like that from Calgary Expo. So Alison counter-offered with a detailed breakdown of what she wanted in monetary damages from each party and why she felt entitled to them. Part of her offer to Calgary Expo included a stipulation that a portion of it could be paid in the form of booth credit for future expos. I'm not sure how feasible that is. It's something that maybe could be accommodated in a settlement, but it certainly would not be accommodated in a courtroom via judgment. Now, Chu responded to that by emailing her to threaten her with a slap defamation lawsuit over Brian's tweet. He had posted "We won!" point on Twitter the afternoon of the final trial date before we were able to inform him of what was actually going on. It referenced neither the defendants nor the trial, could easily be considered fair commentary in terms of we got them to offer a settlement, meaning that being the way we won. Even if it's incorrect, it's a mistake, and also, like, a mistake is not illegal. It can hardly be described as defamatory. And again, the moment we learned of its existence, we not only had him delete it, but publicly correct the record. And also, it was Brian who made the tweet, not Alison. So it was pretty lame to threaten to sue over something like that, especially given that in the 2.5 years since we were evicted, after all the hassle and expense of taking all of this to court, pretty much all the defendants were offering us was what we did automatically without being asked to. Upon discovering the error, we immediately corrected the public record. I'm aware the following isn't really particularly judicial or legalistic language, but what a bunch of dicks. So anyway, at that point, Alison was pretty much done trying to discuss settlement with these people. They were being completely unreasonable and engaging in threats of frivolous and vexatious lawsuits in order to get leverage, I guess, in the negotiations. So she asked Harry to contact the court and get them to assign new trial dates. And initially, the second portion of the trial was scheduled for February of 2019. Yeah, you heard me. February of 2019. And that would have made it 4 years, almost, after we were kicked out of the expo, that the final 3 days of trial would be taking place. So Harry sent the clerk a letter respectfully asking whether the judge might consider rearranging his docket to accommodate earlier dates. And wouldn't you know it, the judge did us one better. He didn't juggle his work schedule. He offered to come in on his days off on July 3rd through 5th, 2018. He's semi-retired. He works for 6 months, and then he takes 6 months off, and he was offering to come in and hear the case on the final few days of his downtime. And I don't even know whether he was being paid, so then Chu writes the court clerk saying that those dates are unacceptable as they fall on a statutory holiday in the U.S. and Mr. Icebrook wouldn't be able to make it. And the court clerk, I believe, wrote back that whether Icebrook was present or not, the trial would proceed on those days. End of story. So I think I'm going to leave it there for now, because that takes us essentially right up to the period immediately prior to this final few days in court. And there are many other interesting revelations to be made, but I don't want this video to be like 3 hours long. So, and I do want, for people who are up to speed on sort of what transpired up until this point, I'd like them to be able to just skip over this entire portion of the story altogether, and I'll be uploading a second video taking it from the days immediately prior to this final set of trial dates and taking it from there. So, I guess that's it for me for now, and I will see you in a day, maybe, to give you all of the lowdown on what happened in this most recent set of dates. So, bye-bye.